Good morning. Good morning. Good morning. Welcome, everyone. Welcome back to Take It to Trial. I'm your host, Sweet Pea Diamond. And today we're going back in the courtroom with Christopher Davis. Today is day 4. Just to give a quick recap, we have heard testimony in regards to video surveillance from Christopher with video from Ace Hardware, purchasing items, also him disposing items. We have seen the first police video when he reported him buried missing. We have heard witnesses testify to hearing him impersonate Barry on the phone with PNC Bank. We have seen him at ATM. We have seen a lot of receipts, right, guys? I know yesterday we left off with the detective. I'm pretty sure this morning they'll bring the detective back. I'm not sure how many of the witnesses we got through. I know they told me 16 for yesterday. They did tell us that, but I don't think we got through all 16 witnesses. This case will, the prosecution will probably rest their case very soon. And then the defense will be up, right? So they have to decide about poking some holes in regards to Barry. In regards to Barry, if he still alive, did he pass away from a heart attack? Because they have been trying to present that information, right? I don't think that they have enough, but we'll see what evidence they try to present to say that Barry just wandered off or Barry has some kind of heart condition or something to that caused him to pass away. Remember, we still don't have a body, so we actually don't know. We just have all this evidence that's circumstantial that is leading up to see to Christopher. Everything is pointing to Christopher at this point in time. So what I'm gonna do is I'm gonna put us in the courtroom. They kind of already started, but I got us some TiVo time, right? That's our thing. I have my McDonald's coffee, right? I love McDonald's coffee. So I have that on deck. We're gonna go in the courtroom. Remember, this is the place. If you don't want any filters, we don't have any fluff, just facts. So you can be the judge, right? All right, guys, let's go ahead and go in.
It's Justin, but she'll be right back. Oh, being stealthy.
All black.
All right. All right. So we're ready to proceed this morning. Okay.
Yes.
That's ready. The minute's ready. My understanding is, do you have anybody else after the next witness?
We do not judge.
Okay. And then, so this is another time, Mr. Davis, we had a discussion yesterday where I just let you know there may come a time you will have to decide whether or not you want to testify or not testify. We're not at that point yet, but with the state's representation, I imagine I have this discussion probably this morning. It is necessary. So just make sure you have time this morning if we're in break or something like that to discuss that with your attorneys if you need the additional time on that decision. Right? All right, then are we ready to bring in the jury?
Yes.
All right, let's bring them.
three.
All right, please be seated. Welcome back, ladies and gentlemen. Good night's rest. By show of hands, was there anyone on the jury who was not able to follow the court's previous instructions about doing any research, looking up anything, or discussing anything about their services as a juror on the case? Seeing the hands, we're ready to proceed. State and call your next witness.
State would call Detective Bierman.
So we have our detective coming back to the stand. I kind of figured he would be the first one up because they tried to call him yesterday when we ended court, but I guess they decided to let the jury go home. So we're back with the detective. And mind you, this detective has been up here at least 10 times. He's coming on like after every other witness.
Once your judges face the clerk, raise your right hand, she'll swear again.
You solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth.
Take a seat. You may proceed whenever you're ready.
Good morning.
Good morning.
Now, you walked us through July 19th, July 20th, July 21st, July 22nd, July 23rd. What was the next date of your investigation?
That was the day that I actually became involved in the investigation, July 24th.
And how did you get involved?
That was the day I was contacted by my supervisors to take a look at the case.
What was the first thing that you noticed that the defendant did on the 24th?
Going through searches and records, we were able to determine that he had gone to the Starbucks and then nail place and Antares Aesthetic Medicine, I believe it was.
And with regards to the nail place, it was called Pretty Nails. Is that accurate?
I believe so, yes.
And was one of Barry's credit cards used at Pretty Nails?
Yes.
And with regards to Anna Teresa Cosmetics, was one of Barry's credit cards used there as well?
Yes.
And what card was used there?
That was the American Express card that was used at Cruisers on the 19th.
Your Honor, permission to publish dates 22 as well as 39 Y. And for the record, 39Y, this is the back of the Discover credit card.
Yes.
And then this shows the charge on stage 22 for Pretty Nails for $65.
Yes.
Easy now, sorry. And you said Anna Teresa Cosmetics was also used on one of Barry's credit cards that day?
Correct.
And it was the same credit card as Cruisers,
Yes.
which is the Amex, which was states 3. So the $10 and the $98.50 was the Cruisers,
Yes.
and the $14.54,
That was the Antares.
and we see that on the next page, correct?
Yes.
And you said he also went to Starbucks that day?
Yes. I believe so, yeah.
Were any search warrants done on the 24th?
Several.
Was there a search warrant done on the residence?
Yes.
What, if anything, did you find in the residence?
We seized Chris's wallet, several items, trash. I'd have to go through the whole list, but there was quite a few things taken out.
Okay, let's discuss the trash. Was there anything distinctive about the trash in that particular unit?
It sticks out that goes up with pink trash bags.
Were you able to find pink trash bags in a dumpster for the condo as well?
Yes.
And did you direct someone to pull the two pink trash bags from the dumpster?
The narcotics unit was
And you followed the pink trash bags all the way to evidence?
I did not know. Those were in the possession of law enforcement officers the entire time. I actually stayed behind. And once the vehicle, which we had gotten a search warrant for that, once the vehicle was towed, I followed the Jeep to our evidence lot since I was a civilian driver. So it was in police custody the entire time.
And the evidence inside of the pink trash bags, it wasn't open or torn when you first
No.
started digging through them?
No.
And you actually went through those trash bags, correct?
Yes, I did.
And what was found in those trash bags?
There was some Home Depot information in Mr. Schmalock's name. There was cardboard paper wrapping for Dolly. There was some duct tape on that, some other trash.
So to direct your attention, you're under permission to publish 12, 48B, 48C, 15, 28B, 2C, 28A, 39B, B, 39U, 39B, 39W, and 39AA.
And all of this being in order, correct?
They've all been moved in, all the evidence for the state's been moved in. Now, with regards to what you just stated, that you found duct tape. This is the receipt from Walmart, and what date was that for?
That was on July 19th.
And what did Christopher purchase at Walmart?
2 rolls of duct tape, Tarp and chocolate milk.
And for the record, that's states 12. Publishing states 48B. And now I know it can be a little bit difficult to see, but this is the cell phone case that matches the cell phone case that was off of Barry's phone, correct?
Correct, yes.
What is this green and white wrapper?
That is duct tape wrapping.
Is that consistent with the same brand of duct tape that Mr. Davis purchased at Walmart that night?
Yes.
For the record, 48C being published. And on 48C, what if anything do you see in it?
That is the wrapping for the dolly.
And I know it's a little bit difficult to see, but do you know what this is here?
That is silver duct tape.
Is that consistent with the duct tape as well as the dolly that was purchased by the defendant?
Yes.
For the record, 15. Is this the defendant with a dolly?
Yes.
And that's the dolly that was purchased at Lowe's?
Yes.
And this is consistent with the same trash that he disposed of?
Yes.
And in this particular photo, on 15, what is this?
That appears to be an Apple iWatch.
And is that Apple iWatch consistent with an iWatch that was recovered from Barry's residence on 24th?
Yes.
Now, in that trash, did you happen to find a harness for a cat?
I did not.
Did you happen to find a leash for a cat?
No.
But you did see cats in the residence.
Me personally, no. I never saw a cat.
So no, there was no cat viciously attacking you.
No.
Did you happen to see any harnesses inside the residence when you did your search warrant?
Not that I recall. No.
Did you see any leashes for the cats inside the residence?
Not that I recall.
Did you also do a search warrant on the vehicle?
Yes.
And with regards to the search warrant on the vehicle, did you find anything in the back of said vehicle?
There was several items found.
You're under permission to publish 2B. And this was in the trunk space.
Yes.
And then we have 2C.
Yes.
This is also a closer up at the trunk space. Is this consistent with the item that Mr. Davis purchased at Walmart on the 21st of July?
Yes.
And you said that you also were able to look at the outside of the Jeep during the search warrant as well.
Yes,
Is this Mr. Smallbox Jeep?
yes, it is.
And could you describe for the jury the outside area of the Jeep as you saw it on the 24th?
Exactly like that. That's actually outside the house. Dirt on the passenger side, around the doors, around the wheel wells, on the back tires.
And you did a search warrant of the house, you found his credit card, or sorry, his wallet, excuse me,
Barry's wallet or Chris's wallet?
Christopher's wallet.
Yes,
Publishing 39U. And what is this a photo of?
that's the wallet. That's Chris's wallet.
And with regards to that particular wallet, what is this item here?
That's an identification card.
Publishing,
Alaska.
publishing 39BB. And this is Christopher's identification card
Yes,
and the date of birth on the card.
6/8 of '88.
And then we have another view of the wallet, which is states 39B. Is that accurate?
Yes,
Does that wallet look different than the wallet that Mr. Davis used on July 19th when he purchased the 2 rolls of duct tape, the tarp, and the Fairfield Light chocolate milk?
no, that was the same.
Are the amount of credit cards different?
From the initial night on the 19th, there's more in there from what I could tell. Just looking at it.
And with regards to 39W, this is the content of Mr. Davis' wallet.
Correct.
Are any of those credit cards Mr. Davis's?
No.
Whose credit cards are they?
They're in the name of Barry Smallbach.
And 39AA and 39B. What is this?
That's the American Express card.
And this American Express card, was that used on the 24th as well
Yes, that's the one that was used in Antares.
for $1,454?
Yes,
When you went into the condo, was Mr. Davis cooperative with you?
yes.
And did he tell you what happened the night of the 19th?
That he and Barry had gone out. They had some drinks. He came home, was very drunk, and passed out. And he woke up at 4 a.m.
And Mr. Davis said he was very drunk, as in Mr. Davis was,
Yes,
and he passed out and woke up at 4 a.m.
yes.
What was the last thing you said to Mr. Davis before he became uncooperative in your investigation?
When he became uncooperative, when we mentioned that he may have been last one seen Barry.
When you did the search warrant on the residence, did you find any items that had a broken screen?
No,
So no watch with a broken screen?
No.
Tablet?
No.
Cell phone?
No.
Were you able to find Barry's phone?
No.
Now, I believe you told us, I think on day 1, that there was a ping done on Barry's cell phone.
correct.
Where was the ping's last location?
But I believe it was within 5,000 meters of the residence.
And for us that aren't familiar with 5,000 meters, how would you describe that?
That's a big area. It's 5 clicks. Probably 2.5, about 3 miles, 2.5, 3 miles.
So you didn't find it in the residence though?
No.
And you say it's kind of a click, so it doesn't give you an actual location, it just gives you an overview.
Well, it's a ping, yes, so it will give us within that many meters. Whenever we have a missing persons case, that's one of the first things that we do is try to ping the phone.
And did you find anything consistent with an accessory of Barry's phone? Such as a case?
We found a case in the trash can, in the trash.
And that states 48B,
That is correct.
and that's consistent with the same type of phone case that Barry had.
Yes,
Did you also do what is known as a body search warrant on the defendant?
yes.
What exactly is a body search warrant?
That's where you take DNA, take photos of the body, consists of mouth swabs, take photos, if there's any injuries, anything like that.
Did you notice anything about Mr. Davis during the search warrant?
Subtle scratches up and down the arms, legs.
And you said you're a high school football coach, correct?
That is correct.
And how long have you been in Southwest Florida?
How long have I been in? 43 years?
Have you ever been around a cat?
Yes.
Have you ever had injuries consistent on yourself with the marks that you saw on Mr. Davis's body from a cat scratch?
From a cat scratch? No.
Now you said not from a cat scratch and hesitated. Is there something that you've done yourself that would be consistent with the marks that you saw on Mr. Davis's body?
Yes.
And what would that be?
Walking around through brush, stuff outside, scratches on trees.
Objection, speculation.
I asked with regards to himself. So with regards to yourself, watching through areas that are more rural and raw.
Yes.
What did Mr. Davis tell you about the scratches on his body?
They were from the cat.
Did he tell you how he got them from the
Yeah,
cat?
he was trying to harness the cat, put leashes on the cat.
Were you able to review a Celebrite report as well after Ms. Fordham was able to do an extraction on the defendant's phone?
Yes.
Did you notice him doing any searches for different Airbnbs?
Yes.
Did you see him do a search for an area called Ochapi?
Yes.
What is Ochapi?
Ochapi is a little town. It is probably, if you go down to Naples, if you take 75, you take 75 across the alley. That's why if you go down 41, you go across that way. Ochapi is a town on that way. It's probably about 40 miles south of Naples into the west or to the east. It's on the way going into the Everglades.
So you would characterize it as very rural,
Yes.
and he was looking for an Airbnb there?
Yes.
And did he end up getting an Airbnb there?
No.
Where did he end up getting an Airbnb?
Close to Monterey States.
Now, during your search, or your review, excuse me, of the Celebrite, did you ever notice him search for an area called Devil's Garden Mud Club?
No, I did not.
And are you familiar with Devil Gardens Mud Club?
I am now.
And is it still an area that is open for the public?
No, it is not.
When did it close?
The last review on the website, the last Google review said it was closed in July of 2020.
Now, did you do anything else with regards to the 24th of July?
Just the search warrants, bringing evidence and stuff like that back to the station.
What was the next day that you kind of became really heavily involved with the investigation?
Well, from that point on, I was pretty much involved all the time.
And are you able to take us to what happened on July 29th of 2023?
We did I wouldn't say a grid search, but a search of a very large area in Clewiston.
Can you explain what a search in Clewiston looks like to the jury?
It was expansive. I think we probably had about 50, 60 people out. Vehicles from Hendry County, ourselves, Lee County came out and helped. We had drones up. We were looking for a stretch not far from there, big inn. Looking down a stretch of road. It was pretty extensive.
And what was the area like out there?
Rural, agriculture, lots of, there were some canals, lots of open fields, lots of open areas.
How were you able to decide what areas to search?
At this point, we were just looking for a big stretch of area that was close to the Airbnb that it looked like it could be accessible.
Would you describe Montour as kind of finding something almost as a needle in a haystack?
Put it mildly, yes.
And why would you say putting it mildly?
It's just so open. There's thousands and thousands of acres.
And it's well developed?
No.
Did you end up finding Barry's body?
No.
Did you end up having cadaver dogs help with your investigation?
Yes, we did.
And do you know where the cadaver dogs came from?
Pasco County.
And why did you have them help with the investigation?
we were looking to see if there would be any evidence of, remains in the vehicle.
And Your Honor's permission to publish states 2E. Do you recognize this?
Yes, those were the vehicles that were used in the search, or in the lineup.
And the cadaver dog you said helped with the search of the vehicle.
Correct.
What information did you receive about how to set up for the search?
They just asked for like a lineup. So we used the Bears vehicle and 3 other employees from the from the police department.
And the 3 other employees from the police department, did you go through their vehicles and clean them before?
No.
Were these well-lived in vehicles?
Yes.
What was the age range and the demographics of the 3 other vehicle owners?
I believe they were all females. They all were from our records department, probably between 30 and 45.
Some of them have children.
Yes.
Were the cars in pristine condition on the inside?
I didn't go through them. I mean, they looked like they were active in use cars every day.
Did you tell Pasco County which car is the one that you wanted them to search?
No.
So what did you have to do once you lined these vehicles up?
We lined them up and then we stepped away and then the dogs did their thing.
And how did you move Barry's vehicle around in the parking lot?
I did not. When the evidence text did that, she suited up in the anti-contamination suits, the white suits that you normally see with boots and gloves, and she moved it.
The other drivers for the other vehicles, were they suited up the same when they moved their cars?
No, they moved their cars.
So you witnessed Miss Buckner going into the vehicle in a contaminated fashion, not to leave any sort of hair, body.
Yeah, and I saw her get out of the vehicle. I didn't actually see her get in the vehicle. If you look in that back building on the right corner, that's the garage where I was parked at. So I saw her when she got out.
Was the Jeep kept in a way not to be contaminated by other vehicles?
It was locked up in its room by itself until we released it.
Did you actually witness the dogs run?
Yes,
And how did they run that day?
I believe one was off leash and then they put it on leash. I don't remember the second was off but on.
Were they running both dogs at the same time?
No.
Were they watching each other as they were running the dogs?
No.
You never told them, or anyone told them, which vehicles were where?
No.
Since Barry went missing on July 19th, 2023, were you able to look to see if he flew out of RSW at all?
He did not.
Have you yourself flown before?
Yes.
And what items do you need to be able to get into an airplane?
One is ID and 2 is ticket
How do you usually purchase a ticket?
with the credit card.
Did you also have a passport?
Yes.
Did you find Barry's driver's license
Yes, on the 20th.
in the wallet?
Yes.
And did you find Barry's passport
I believe it was in the safe when we got into the safe.
on the 24th?
I don't know if it was the 24th when we actually got into the very safe. I think it was a little bit later than that.
Are you aware if you ever applied for a new driver's license?
Not that I'm aware of, no.
Are you aware if you ever applied for a new passport?
Not that I'm aware of, no.
Has there been any other activity on Barry's accounts other than what the defendant has used his credit cards for since the evening of July 19th, 2023?
Other than them not being paid, there's been no activity at all. No payments, no nothing.
It's been mentioned by witnesses that Barry was flying to Chicago in August. Were you able to verify when he was supposed to be flying to Chicago?
I believe it was, I want to say it was August 2nd. And I actually called out to the airport that day. And I had the police department out there make contact with the airline to see if he had checked in, if anybody had flown, and they said no. And they actually did there's LPRs out at the airport, and actually did LPRs for the vehicles and stuff that were assigned to either vehicle, and there was no activity at all.
When was the last text message that Barry sent out?
last one from his phone was around. I have to look again, right? So I would say it was 7 p.m. Something like that. It might have been later.
Would you say that the last activity on his phone was at about 9:30, whether it be text message, phone
Yes.
calls,
Yes.
and he never called out after that time?
No.
He received multiple calls in,
Yes.
but none of them were answered other than a PNC call.
Correct.
Is the last time anyone sees Barry on any sort of camera the one at Greco's Drawers?
That's what I've been able to. Of course, my investigation. That's the last time I was able to obtain that information.
And the passport of Barry's, was that near or in the backpack in the office area of the condo?
I believe so.
And to your knowledge and through your investigation, who was the last person to be with Barry?
Well, we've been the last person on video with him. So Christopher.
No further question.
Indicated the search of the condo.
Yes.
Did you recover firearms?
Yes.
How many firearms were in there?
I'd have to look at the inventory return. A couple handguns, I think, a couple long guns.
Okay. There were various firearms?
As far as we were able to check, yes.
Okay. And in the course of your investigation, you ended up actually talking with a person named Tyler Gamble?
Yes.
Okay. You took a statement from him?
Yes, over the phone.
Okay. And it indicated to you that it wasn't uncommon for Chris to use his Airbnb account because Chris's account got closed?
Yes, he said that there was an issue with Chris's account for a place that they stayed in Vegas that got messed up. And after that point, he used it.
All right, and then you indicated the search warrant was done on the Jeep, and you actually stayed back and then followed the Jeep to, I guess, the evidence?
Yes. Once it was hooked up on a tow truck, I followed the tow truck to the station.
All right, so if you recall, how do they tow it? Do they put it like on dollies? or
They put it on a flatbed.
Do they pull it up
Yes, sir.
like a wire and cable?
Yes, sir.
Do they pull it up from the rear,
No, I believe it was front.
from the front end?
Oh, well, actually, they backed it out from the front and then,
Okay. And then
because it was pulled in that way, we would have to pull it out from the back.
this is a tow truck company, you just call whoever's on the road.
We have, for cases like that, we have one tow company we use. I don't remember the name of it off the top. That's not a rotational tow. That is a one for search warrants and stuff like that. And stuff like that is one company.
All right, and you said you never saw cats in the condo?
I did not know.
Do you know who removed them prior to you getting there?
I don't know if they were removed or not. I did not personally see them. I don't know if they were hiding under beds or anything like that. I just did not see them.
All right, and then there was talk about the charge on the card at Anna and Teresa.
Yes.
Did you learn that Mr. Davis had previously been there for a consult at one time?
I'd have to go back and double check that.
Okay, I was gonna ask you if you had any idea if that card was already on file from when he did the consult. Would you know that?
No, without looking at my records, no.
All right, and you said the last ping of Barry's phone, the location was 5,000 meters
I believe that was correct, yes.
of the condo.
Yes.
And would that include the area where the wallet was found in the drain?
Yes.
Then passport, I was confused about the location of that. Was that in the safe or was it near like a backpack and some medicine?
Actually, I misspoke. It was not in the safe. There was a lot of personal identification stuff. The passport was in the house.
Okay. in the search warrant of the condo, did you come across syringes?
Yes,
Okay, and then some of them were used syringes?
yes,
And that was, I guess, investigation led that it was medication Barry apparently was taken.
yes.
Thank you.
Yeah, follow up, Your Honor, we asked to retain, but
May
we
step
not,
down, but you're not released.
at this time, Your Honor, the state rests.
Okay. Ladies and gentlemen, I'm gonna send you back to the jury room for a few minutes. We'll call you back out. All right.
So the state has rested their case. Have they presented a clear timeline to everyone? What do you guys think? Do you think that Christopher has killed Barry or unalived Barry, I guess is a better way to say? Or is Barry still out there? Did he pass away from some heart condition? What do you guys think? Did the prosecution actually provide a great timeline for everybody? Is everything leading up to Christopher? Please drop your thoughts and comments in the chat. And the state has rested. I just wonder with the defense, I'm pretty sure they're about to move for a motion for acquittal. They're probably going to go through some information in regards to if Barry wants to testify. So we'll see. We'll stay in the courtroom for a minute to see what things they're going to do outside of the presence of the jury.
We'll address it one at a time, Your Honor. First off with the, Your Honor, so for count one, second degree murder, we would be arguing at this time that the state hasn't presented proof sufficient to establish what is required for this court. Specifically, we're arguing that they're relying on improper inference stacking. So the first case we're citing to is Gustine v. State. It's a Supreme Court of Florida case from 1923. The citation is 97 Southern 207, 1923. It's the case that establishes essentially inference stacking. It's an attempted larceny case, but essentially, the facts are that the defendant was charged with attempted larceny. The defendant did not start the car, though he manipulated wires, and the court ultimately overturned that conviction because the facts and proof are equally consistent with some other rational conclusion in that of guilt, the evidence is insufficient. And if the evidence leaves it indifferent, which of several hypotheses is true, or merely establishes some finite probability in favor of one hypothesis rather than another, such evidence cannot amount to proof, however great the probability may be. And so essentially, this is an old case, but this case was expressly upheld still, even after the change in the JOA arguments by Garcia v. State. And that's going to be the case 373 Southern 3rd 1213. That's the Florida 3rd District Court of Appeal from 2023. And they specifically do a whole analysis on whether this is still good law. And they explicitly find that Gustine's legal principles prohibiting a conviction based on the pyramiding of inferences remains valid, even after the Bush opinion that eliminated the special standard for JOAs. I would direct your attention to page 27. That's essentially kind of where the analysis holds that, and also the analysis on Gustine still being good law. And that's based upon them finding that sister courts are still upholding it, as well as the use of the axiom of sub silentio. Basically, Florida Supreme Court does not overrule itself silently; they do it expressly. And it's actually important to note that in Garcia v. State, the 3rd District Court of Appeal certified this question, like, is Gustine still good law? They certified it as a matter of great public importance to the Supreme Court, but the Supreme Court ultimately denied review of that case. and it was established and stayed that same way. So, they go on to basically say circumstantial evidence is proof of certain facts and circumstances from which the prior fact may infer the ultimate facts in dispute existed or did not exist. But I think our concern here is that there's not enough evidence in our case to elevate the disappearance date to an established fact beyond reasonable doubt. So there is this sort of subset of case law in the inference stacking, which basically implies that certain facts, if there's not another reasonable hypothesis, can become established facts. But the issue really for this case is that this is known as what's called the Volcker exception. Essentially that an inference may be admissible into evidence and it can be the cornerstone of other additional inference stacking if it's, to that degree where that fact has been established to a reasonable doubt. Interesting to note, though, is they do a whole analysis on this exception. It's only been adopted by the first and second DCAs here in the state of Florida, specifically for criminal cases. And the third DC actually decided not to even adopt it. And it's mostly done in civil cases, but has been slightly adopted. So, the standard, this Volcker exception, is when no contrary reasonable inference may be indulged, such an inference is elevated for the purpose of further inference. We would be arguing that no evidence actually exists to elevate any of the facts established here by the state so that this inference stacking can occur. Garcia is a very on-point case, very similar, alleged homicide, no body was found, similar facts. There's these allegations of fraud in this case, but that's about a check fraud, but still very much on point. And they really start focusing on the fact that there's this date after which nobody hears from the alleged victim within Garcia's case. And that's very similar here. They note in Garcia, which is these facts are similar, that, basically no body's ever recovered, there's no exact time of death, no crime scene to establish the location, time, cause, or manner of death, no eyewitnesses to the death, no confession. Similar to our cases, there was some evidence introduced through statements by Mr. Davis to the police that there was some sort of Italian dinner plans being made. There were some text messages about that, as well as text messages which show that there was maybe communication after the time frame the state is attempting to show that Mr. Smallbach disappeared or something occurred to him. We've heard evidence that the text messages were slightly different, space, period, space, but even within those text messages submitted into evidence by the state from June of 2023, a month before the alleged disappearance, you see that there's times where Mr. Smallbach doesn't use that space, period, space, even though, there's this whole line of questioning and evidence suggesting that he's very consistent with his punctuation, even though we see the inconsistencies within the evidence admitted into evidence. And again, at this time, the 6th DCA hasn't adopted this. This is only the first and second, and some jurisdictions haven't done this. Specifically, the third hasn't adopted it. So we would argue that even if the court thought that this rose to that level of beyond a reasonable doubt at the time of the disappearance, this court would have to adopt this standard by one of the other courts. Otherwise, it would just be another inference upon which they would have to stack other inferences. So going further into it, the court also found in Garcia that the jury could not reach the conclusion with inference stacking that the death of the victim was caused by criminal acts the defendant in Garcia could because of the pyramiding off of the foundation of the victim's death on a particular date at a particular time. An impermissible pyramiding of inferences occurs where at least two inferences in regard to the existence of a criminal act must be drawn from the evidence and then stacked to prove the crime charged. And in that scenario, it said that the evidence lacks the conclusive nature to support a conviction, basically the same language that they're pulling from Gustine after they found that it's still good law, even after that change in 2020, 2021. Again, they also note that there's a difference between inference stacking and putting the pieces of a puzzle together, suggesting that, in some cases, defense counsel might argue that, we're arguing it's inference, but in this case, the state was trying to argue that they're putting the pieces of a puzzle together, We would argue that the state hasn't put the pieces of a puzzle together. Essentially, they bought a puzzle from Goodwill, doesn't come with all the pieces, Chief Judge. In Garcia, the DCA found that the puzzle the state argued for was missing significant pieces of evidence that required the jury to resort to sheer conjecture and speculation to fill in major gaps. Again, they cite to certain missing items: no established time of death, no crime scene to establish location, cause, or manner, no weapon or eyewitnesses, no confession. Despite missing evidence, the state wanted the jury to fill in the missing evidence from the chronological inferences from the circumstantial evidence which was being presented to the court and the jury, which is essentially what we've seen here in Mr. Davis's case. Ultimately, several of the facts are very similar to what we've seen here. And actually, they even have a little bit more evidence in this Garcia case than what's been presented to the court. In that case, there was this whole thing about Garcia going on and trying to show that the deceased was still alive, driving the car, making ATM withdrawals. We don't really have some of that evidence similar to this. There is something interesting in the Garcia case, which I find very distinguishing, is that they did luminol testing in the vehicle, and they found a hammer outlined by luminol in the interior of the car. And then they speculated that they used the car to discard of the hammer, also a purse that was outlined by the luminol, and possibly a body. We didn't really see that. They just had some generic, like, oh, there's some stains, nothing like the luminol, which would give maybe a presumptive positive that there's blood or something evidence there. They also go on to elicit that, the car was still present. It made it seem like he was still present, things like that, none of which is here in this case. They talk about in this case that the cell phone continued to have activity for several days after the incident, but ultimately, there's been some suggestion of that, but no actual proofs, just another inference. So ultimately, they overturned that conviction for the second-degree murder and reversed and remanded for the JOA to be entered because it was just a lot of inference stacking without that foundational base that was necessary. I've also cited here Ferris v. State, which cites two. So Ferris v. State is 2025 Florida Appellate Lexus 2544, Florida 4th DCA 2025. That cites to O'Flaherty Lewis v. State 237 3rd 15, Florida 4th DCA 2017. And it does have the notation cleaned up, but it's the 4th DCA cleaning it up, so I'll let it be what that is. But they do make a mention: direct evidence of intent is rare, and intent is usually proven through inference. Thus, they're going to have to establish, besides through an inference, that there is some sort of depraved mind, mens rea, that's required for a second degree, and we don't believe that's evident here unless they do these impermissible inference stackings. Especially with the idea that from the 4th DCA that intent is usually proven through inference. And again, the crime of second-degree murder, however, requires the more serious mens rea, which I was mentioning about the unlawful killing of a human being when perpetrated by an act imminently dangerous to another and evincing a depraved mind regardless of human life, although without any premeditated design to affect the death of any particular individual. And a lot of the cases on that point, it's usually like a stabbing. Well, the act of stabbing itself is of the depraved mind. Oh, there's a shooting, the gun was very close to the head. That would show that depraved mind. We don't have anything of that here, Your Honor, so we would argue that it's all impermissible inference stacking. We'd also point out to Light v. State, essentially proving that the defendant's intent or state of mind, which is critical for second-degree murder, can be particularly challenging without a body or clear evidence of the circumstances of the case, of the death. And in that case, the court noted that second-degree murder typically involves ill will, hatred, spite, or evil intent, which can be shown circumstantially, but again, we would be arguing that it's all related to the inference stacking. Now, going on to the count 2, tampering. The tampering statute outlines It is unlawful for any person knowing that a criminal trial, proceeding, or investigation by a duly constituted prosecuting authority, law enforcement agency, grand jury, or legislative committee of the state is pending or is about to be instituted. That's 918.13 Florida statute. Specifically, A states alter, destroy, conceal, or remove any record, document, or other item with a purpose to impair its verity or availability in such proceeding or investigation. I'll actually draw the court's attention to 918.13 subsection 1A, where it specifically states alter, destroy, conceal, or remove any record, document, or other item. It's very specific language. We would actually be objecting to count 2 in their jury instructions for the state. I noticed it this morning, just these arguments, we'll go to that later when we have our charging conference, but they actually included a broadening of that language to include remove any record, document, or thing. An item and a thing are very different, and we would be arguing that they're essentially broadening it. We would be just relying on basic statutory interpretation. Basic rules of that law should be given its plain meaning. If it says something very particular, it means that very particular thing. In criminal law, we have the expression expressio unius est exclusio alteris, the rule that, there's a term of limitation. Anything not included must be excluded. So when they're saying a thing, we would be arguing that an item and a thing are different, and we would even argue that an item is not a cadaver or body, if that's what they're suggesting was actually tampered with in this case. One of the other statutory interpretations is that statute should be interpreted so as to be harmonious with other laws. And there are other Florida laws dealing with the improper disposal of a corpse or a cadaver. That's 406.11, 406.12. For instance, that gives the requirements for disposition of human remains, specifically that when any person dies in the state of criminal violence, it's to be reported to the medical examiner. And then 406.12, duty to report and prohibited acts. So we would be arguing that this statute is not in harmony with the other statutes, so we would be asking for a judgment of acquittal on that as well. And then lastly, counts 3 through 10, criminal use of personal identification of the deceased. We're going to argue essentially inference stacking as well. There's been no evidence introduced that Mr. Davis did not have the permission of Mr. Schmalbach to use the credit cards that he was alleged to be using, or has been using, sorry. Specifically the statute. The statute under which he's been charged, 8A. So 817.5688A Florida statutes, any person who willfully and fraudulently uses or possesses with intent to fraudulently use personal identification information concerning a deceased individual or dissolved business entity commits the offense of fraudulent use or possession with intent to use personal identification information of a deceased individual. Our focus is really on the who willfully and fraudulently uses. Willfully means intentionally, knowing, and purposely, while fraudulently means purposely or intentionally suppressing the truth or perpetuating a deception. Again, even the state's own evidence submitted into trial, such as the Discover records, they point that there was all these payments after 7/19, they were paid by the card, they were paid by the Apple Watch, but we also see those exact same payments before 7/19, whenever Mr. Schmalbach was still answering calls and things like that before his reported disappearance. And that's what I'm going to draw your attention to Tinker v. State, and they just go into an analysis on willfully and fraudulently, and specifically as to a deceased individual. That one's more about property fraud, things like that, but it's directly on point with this because it is an analysis of this particular statute. We also heard from, the witness from the Annalise Theresa anesthetic medicine place. That's very common. It's not uncommon for spouses and partners to use significant others' payment methods. And we heard from, at least one or two witnesses, specifically at least Ms. Gleason, someone who actually knew about the relationship between Mr. Davis and Mr. Schmalbach. Now, this was a relationship unlike any that she had seen Barry have in the past. So we would be arguing that essentially that kind of shows this continued permission. And there would also have to be, the inference that he was using it fraudulently, but also the inference that Maybe Mr. Davis even knew that there was Mr. Schmalbach became deceased, even though there hasn't been really a showing of direct evidence. Again, it would just be an inference. So with all of that, we would just be arguing for a judgment of acquittal on all the charges at this time, Your Honor.
State response.
Absolutely.
If I may approach. Judge, I'm going to hand the court what's previously, or it's going to be identified as Crane versus State, 894 Southern 2nd, 59, Supreme Court Florida decision out of 2004. Myers versus State, which is a Supreme Court decision out of 1997, cited at 704 Southern 2nd, 1368. And Sochor versus State, which is cited at 619 Southern 2nd, 285. 1993. Court will note those are a little bit more recent than the 1923 case defense counsel cited. Judge, despite the inability of authorities to find the victim's body in this particular case, there is competent, substantial evidence to establish that Mr. Schmalbach is in fact dead and that Christopher Davis is in fact the one who killed him. Corpus delicti in this particular case, Judge, can be proven circumstantially, even without evidence of the discovery of the victim's body. We've established the corpus delicti based evidence of a 58-year-old victim's character, traits, habits, and relationships, which negates theories of suicide, natural death, accidental death, justifiable or excusable homicide, or continuing life in absentia. Based upon the totality of these circumstances, Judge, this constitutes substantial competent evidence from which the jury could reasonably have excluded all inferences other than the fact that Mr. Schmalbach is dead and that Christopher Davis killed him. Defense counsel wants to go ahead and allege that we have impermissible inferences and stacking. But in this particular case, Judge, the case law specifically cited by the state with regards to Myers, Crane, and Stoshore, specifically, the state must establish the fact of death in this particular case and that the criminal agency of another as the cause thereof and the identity of the deceased person. And that is Crane versus State, 894, Southern 2nd, 59, 2004, citing Myers versus State at 704, Southern 2nd, 1368, which is that Florida Supreme Court 1997 decision. Now, regarding the second element of criminal agency of another, proof need not even show that the defendant is the one who committed the crime. What we need to establish, Judge, is the fact that the victim was in fact, what we have in fact established is that the victim was reported missing on the 23rd of July, 2023 by Mr. Christopher Davis at the behest of his friend, Mr. Miguel Blanco, after not having seen or heard from him since he left Cruisers that night, which would have been on the 19th of July, 2023. Family, friends, neighbors, and colleagues stated that it was not unusual for him not to contact them. They stated that it was unusual for him not to call, text, or email, even if he planned to be gone or when he was to return. Most of Mr. Schmalbach's belongings, including his identifications, were still at his residence. The victim's family and friends also reported him missing on or about that same time after not hearing from him. Mr. Schmalbach has not been seen or heard from by any of his friends, his family, his acquaintances, and or co-workers since his disappearance. The facts surrounding his disappearance indicate that such an absence without contacting family or friends are out of character for him, and the fact that his belongings, his medications, his identifications, his valuables, as well as his vehicle were left at the residence indicates that the absence was not of his own volition. And in addition, Judge, the continued absence of Mr. Schmalbach, along with these facts, indicate that a death resulted from the criminal agency of another. In addition to Mr. Schmalbach's body never having been found, we offered the following circumstantial evidence. We offered that there was in fact an argument. There was a struggle in the condo. There was a removal. There was relationships with his family, friends, neighbors, and colleagues that have not been acknowledged by anyone and responded to by anyone. There was no expression of any desire or intent to leave any of his family, friends, or neighbors by Mr. Schmala. He was looking, in fact, forward to work and spending time with his friends and family up in Chicago. He always let someone know when he was going, when he was coming back. His wallet was left behind, containing his identification, his credit cards. And not only was that only seen on the 22nd, Judge, but later it was disposed of and recovered on the 28th. His watch was also left behind. You heard the fact that he walked and wore that on a regular basis. He left his passport. He left his Jeep, which was his business. His safe and his contents were also left behind. None of his things were missing from his room. His phone records of his last text and call were July 19th, 2023. Cadaver dogs alerted to the back of Mr. Schmalbach's Jeep. The lengths of which Mr. Davis undertook to cover up his deeds with the texts, the credit card usage, and the changing of the door locks, we have introduced sufficient circumstantial evidence to prove that, in fact, the corpus delicti of a homicide has, in fact, been established, Judge. The standard of review is asking simply whether the state presented competent, substantial evidence to support the verdict, Judge. Should be used in all cases when the sufficiency of the evidence is analyzed, even when the conviction is wholly based upon circumstantial evidence. And if I may approach, Judge, I'd like to provide a case to the court. It's cited at Bush v. State, 295, Southern 3rd, 179, 2020. Once again, another Supreme Court decision out of the state of Florida. In that case, Judge, the court cited that the court must view the evidence in light most favorable to the state. Maintaining this perspective, asked whether a rational trier of fact could have found the existence of elements of the crime beyond a reasonable doubt, whether there is substantial competent evidence to support the verdict and the judgment, substantial evidence as such, relevant evidence as a reasonable mind would accept as adequate to support a conclusion, and instructing the evidence is competent if it is sufficiently relevant and material. This standard should now be used in all cases where the sufficiency of the evidence is analyzed. Judge, based upon all of the facts and circumstances the state has provided to this specific court, this evidence that we have laid out over the past 3 days alone is sufficient to sustain a conviction for second-degree murder. As it relates to the Sochor case, Judge, I would specifically point out in that particular case, the court found that evidence that a victim was last seen screaming for help with the defendant on top of her, and that it was uncharacteristic for her not to come home, and that none of her belongings were missing from her apartment was sufficient to establish corpus delicti for a murder, although the victim's body was never found. And they even went so far as to say, in proving that the corpus was sufficient, the circumstantial evidence is sufficient, and proof beyond a reasonable doubt wasn't even necessary in that particular case. In that case, Judge, the facts were such that the victim disappeared New Year's Eve, not been seen from or heard from that night. It was uncharacteristic for her not to come home. She had a good relationship with her family and her boyfriend and kept in touch. None of her belongings were missing from her apartment. There was information regarding the victim that she was screaming for help with his brother on top of her. They found that was sufficient evidence that the victim was in fact dead and that her death was due to the criminal agency of another. And Sochor piggybacks more or less, Judge, off of the Crane decision. In the Crane decision, Judge, the evidence there was sufficient to establish corpus for a murder. And in that particular case, Judge, they found that in addition to an abrupt and permanent disappearance of a young child, supporting the inference that the person was dead, there was evidence that she was last seen alive in the presence of the defendant, that her blood was found on his boxer shorts, and that scratch marks were consistent with fingernails that were found on his body. And although independently not determined, they noted that the defendant oddly targeted bleaching of his bathroom in the middle of the night, along with his unusual behavior the next morning, supporting conclusion that the defense actions with the girl the previous evening was unlawful and resulted in her death. They concluded that the totality of the circumstances constitutes substantial competent evidence from which the jury could reasonably have excluded all inferences other than that she was dead and the fact that the defendant killed her. Based upon all that, Judge, we established beyond the exclusion of reasonable doubt, even at the bare minimum standard at first JOA, that all inferences are drawn in favor of this, should be drawn in favor of the state. We've established second degree murder. Now, with regards to tampering with evidence, Judge, we've clearly established that. We're not saying that he got rid of the body and that was the tampering of evidence. What we're suggesting, Judge, is the fact that he got rid of the wallet, and not only that, but he also got rid of the pickaxe and the shovel. Those were items that he knew that there was going to be a investigation, that there was going to be a prosecution. So he got rid of those particular items. Now, as it relates to the fraudulent use of personal identification information, you have an abundance of information with regards to the use, the videos, and all of the records, the bank records, the photographs, the receipts of all these various places in which Mr. Davis decided to help himself to Mr. Schmalbach's credit cards, personal identification information, even the phone calls where he tries to feign the fact that he's in fact Mr. Schmalbach when he was in fact not Mr. Schmalbach. Judge, all that occurred after the fact that Mr. Schmalbach went missing on the 19th of July 2023. And he wants to say he had permission. We suggest that he did not have permission, especially after he killed him and got rid of his body. And based upon that, Judge, the state respectfully requesting the court to deny the motion for judgment of acquittal at this time.
Mr. Reddick, your vote?
Yes, Your Honor, just briefly, if I may. The state cites to Socher v. State, Myers v. State, Crane v. State, all older cases. You know, they point out my case is 1927, but it was expressly upheld by 2023, the most recent case. We would also point out that Crane v. State deals with corpus delicti. Not really relevant, we would argue here, based upon the inference. You know, they specifically, in the case notes here, Myers talk about corpus delicti in a homicide case, state must establish fact of death, criminal agency of another, and identity of the deceased person. And more importantly, that, you know, typically corpus delicti deals with proving this element before the defendant's own confession is introduced into the record. We don't even have that, Judge, which actually goes back to the arguments we made about Garcia. There's a general lacking of this solid evidence, and it's all inferences that the jury would have to make and impermissibly stack to get to where they could, you know, make a determination here, Your Honor. You know, we talk about Socher v. State here. That's the case cited to evidence that victim was last seen screaming for help, the defendant on top of her. We don't have any of that. That it was uncharacteristic for her not to come home and that none of her belongings were missing. If the court, you know, looks at Garcia, I mean, they do even find that, you know, there is enough circumstantial evidence in that case, we'll admit that, in Garcia, that essentially, you know, a lack of communication, you know, and a showing of constant communication before could be enough to establish that inference. But what our concern is that in that case, they had to essentially, the court had to show that that first inference of the date of the death of the victim in Garcia was in fact the foundation upon which other inferences could be built off of. And as a result, only the first and second districts have done that. 6th district has not, and other districts have not, the 4th and 3rd included. So we would be arguing that this court would have to find that that fact was established beyond a reasonable doubt to allow the inference stacking of everything else. You know, they talk about, oh, there are scratches in this case for Mr. Davis. That's been, you know, explained by, there was suggestions of cat scratching. They want to infer, again, that it was from these bramble bushes or something out in the pokies of Hendry County, essentially. Glades County, I believe. But, you know, I mean, you know, we talk about cat scratches, I mean, but they're so anonymous, synonymous with cats. I mean, you know, talk about oldies and, you know, it's a goodie. You got Ted Nugent's cat scratch fever. Everybody knows about cat scratches. It's a thing. So again, there's these reasonable inferences that can be inferred, and nothing's been established beyond a reasonable doubt to start stacking these inferences. So we would just argue for the judgment of acquittal at this time, Your Honor.
All right, I've reviewed all case law, and I've reviewed these cases actually prior to your motion. And I've reviewed state's cases as well as the defense cases. I've also reviewed all applicable statutes and considered the testimony and evidence presented thus far in the trial and denied the motion for judgment of acquittal. Now, Mr. Davis, this is where we would have a conversation if necessary regarding whether you want to testify or not testify. My understanding from your hearings is, other than yourself, that you do not have any other witnesses to call. So have you made a decision? Have you had an opportunity to talk to your attorneys about whether you want to testify or not testify?
Yeah.
Okay, have you made a decision in that regard? And what is your decision? Okay, you need any additional time to talk to your attorneys? Very well. So we bring the jury back in, and then if it's arrest, is that correct?
Yes.
Okay. And then we would probably send the jury out and have a charge conference, and then come back with closing arguments. Do you have any kind of estimation in terms of how long the closing arguments might be? I'm not trying to pin you down completely. I understand it's had several days of evidence and testimony. And the only reason I'm asking you this is if we do the charge conference, and then start, bring the jury and start the closing arguments, and then have a lunch break and do closing arguments, that's probably not ideal. So what I might consider is doing the charge conference, we'll go over that, let the jury be excused, maybe take an early lunch, and then come back, and then we can start closing arguments and go straight through that. That's just my idea, but I'm open to other ideas.
We would argue probably for an hour and a half for both the state's first votes and the public votes.
Defense would be that or less.
Okay. So, what do you all think? It's 10:15 now. I can bring the jury back in, the defense rest, let them go for an hour or so, and maybe get an early lunch, and come back. We can start before noon. I'm not saying we have to wait till afternoon, but what are your thoughts?
Yeah, Judge, I think the state's in line with the coordinates. They would echo the court sentiments with regards to engaging in the charge conference. Obviously, there's some issues that we need to address as it relates to the various jury instructions. I think it might be prudent to let them go at this point in time. Perhaps.
And I can let you all have some lunch too. I'm not trying to deny you all that opportunity.
Yeah, I don't know about that, but other than that, we are ready to go forward, Judge. Yeah, we echo the sentiments and concern report.
Ms. Commissioner, Mr. Wade?
Sounds fine.
Okay, so let's say we let them out, come back at a charge conference is going to take. Do you have any significant legal objections or anything to the,
Just the one issue. you kind of mentioned.
the wording? Is that going to be?
That's not good. We should have more
Okay.
of that.
So then maybe have them come back at 11:30 be sufficient.
Yes, Judge.
That gives us time to have a charge conference and for you all to step out and get something yourselves or prepare whatever you need to do.
Perfect, thank you.
Is that all right with the defense? All right, so let's bring them in. You can rest and I'll tell the jury here's still 11:30.
Okay, guys, they're bringing in the jury. So Chris decided he's not going to testify. It doesn't seem like the defense is going to put on a case. So it looks like they're bringing the jury in and they're going to do some instructions, and then we're going to kind of probably go into closing arguments. I kind of figured that the case was going to be going to the jury pretty soon, but his motion for acquittal, that was denied. It's going to the jury. He's not testifying. Here we go, guys. They're coming in.
All right, please be seated. Both the state and defense have rested their case. What I'm going to do is I'm going to let you go early for an early lunch, and then come back here at 11:30, and then we can proceed at that time with closing arguments. So it's 10:15 now. You have a little extra time, and just be back here at 11:30, please. Remember the court's instructions. Don't do any research, look up anything, or discuss anything about your services as a juror in the case. Don't watch any local news or read a newspaper or anything at this time. And we'll see you back here at 11:30. Just leave your notepads here.
All right.
Wow, they are definitely taking an early lunch here, guys. Unfortunately, I don't think we have any. Let's see what TiVo time we have. Let me check. Give me 1 second. I'm going to see if we have any TiVo time. We have some. Let me see if we can get. No, actually what they did is they're sending the jury to lunch, but they're going to be arguing still and working through the jury instructions. So we'll stay tuned in. I guess we don't need TiVo time. Yay. Okay, I'm taking this back. I'm going to rewind just a little bit since I was talking over it. Sorry, guys.
And you're saying the standard instruction says item?
The information says thing too, but the statute, the jury instruction indicate or other item,
You said the statute and the standard jury instructions say item?
or other item.
Any objection to changing that?
Not at all, Judge.
All right, so we'll change that. What's the wording you want? Or other item?
Altered, destroyed, concealed, or removed any record, document, or other item.
Okay,
With the purpose of harassment.
so just or other item instead of it. Okay, we'll make that change. Count 3 is a fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual. Prince Tarp.
Okay.
Count 4, fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual. Publix.
Okay.
Count 5, fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual. PNC Bank.
Okay.
Count 4, 4, fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual, for in Starbucks.
Okay.
Count 7, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual at Walmart.
Okay.
Count 8, fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual, for in Seacoast Bank.
Okay.
Count 9, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Home Depot.
Okay.
Count 10, fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual, and Therese Aesthetic Medicine.
Okay.
Deemed not guilty, reasonable doubt, and burden of proof.
No objection.
Weighing the evidence. This is where we have the itemized things that sometimes apply or don't apply. Are there any of those itemized things that we'd like to take out?
Is 6 gonna come out?
That was 6, this has the witness been offered or received any money, deferred treatment, or other benefit, testify. We'll
Correct.
take that out.
Yeah.
Any objection from the state?
Not at all, Judge.
All right.
I think we probably go all the way down through 10, 7, 8, 9, and 10 should not even include that.
Any objection?
Yes, we would like 8 to remain, but
Did
6.
the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Okay. You want to keep that one in, but the others are okay to take out?
Sure, yes.
Okay, we'll take out 6, 7, 9, and 10. We'll leave 8. Is that okay with the state?
Yes, sir.
Then on the second page, there's a section to give only if defendant testified, so we need to take that out. Just that paragraph. That's on page 27. I know in the standard instruction, I think they have other sections for like child witnesses and things like that. Looks like that's already been taken out, but
Yes, sir.
any other objections or additions or deletions to that instruction on weighing the evidence? Anything else?
No.
Okay. Defendant not testifying. Any objection?
No.
Defendant statements.
No objection.
Rules for deliberation.
No objection.
Cautionary instruction.
No objection.
Verdict.
No objection.
Verdict form.
No objection.
Single defendant, multiple counts.
No objection.
Submitting the case to the jury.
No objection.
So we get to surely alternates, so at the end of the instructions, I'll have them not go back for deliberation. Is that everybody else's understanding and agreement?
Yes, sir.
Yes.
What did you say?
So, Gates, sort of, the 2 alternates, so in other words, I'll have them repeat the here and the other jurors are sent back.
Are you talking about what evidence?
No. Now, on the evidence that you want to send back, we've to closing arguments. Is that? You don't do that, I think.
Yeah, I did get an evidence exhibit list from Madam Clerk. I will send it to opposing counsel. I did send it to them.
Okay. Very good. And just let me know what you got. Can you print out a clean copy? I know we didn't change much. Well, what did we change? Weighing the evidence
Weighing the evidence and tampering with this one.
and the tamper. If you could just print out a clean copy again, 'cause I don't know if it changes the play page numbers or not. That's why I don't let it.
I've got a full new copy from the original.
Thank you. Yeah. Anything else the court needs to address then?
No, Your Honor.
All right, I'll let you do that, and then we can recess until 11:30. All right. All right. Just get a clean copy, just put it up here. Got it, make sure it gets one, and confirm everybody's. See you recess till 11:30.
Well, they didn't have much to argue in regards to the jury instructions, so they are now going to lunch here. I'm gonna go check and see what time we have as far as TiVo time. Let's see here. I'm gonna see if I can bring us back in. That would be awesome. I just don't know if we have enough. Yeah, so it doesn't look like we have enough TiVo time, unfortunately. That's why I try to start the trials a little later. Let me know in the comments what you think so far. Is this going to be a quick verdict, or will the jury have issues with we have nobody? We just have a lot of evidence, a lot of video, a lot of receipts. What are your thoughts in regards to that? If you were a juror on this case, would you feel guilty of manslaughter with nobody? No evidence, no witnesses. Well, I ain't gonna say no evidence. I shouldn't say that. No direct eyewitness evidence besides the guy that seen him dragging the tarp out of the building that night. The neighbor who heard him saying no, 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 no. Like, what are your thoughts in regards to that? Would you convict? Definitely put your comments in the chat room in regards to that. So I think that what we'll do at this time is I guess we go to lunch with them since they're taking an early lunch, because it seems like we're going to have a straightforward afternoon courtroom, right? So I think that I'll go ahead and we'll end this stream, and then I will send out a reminder. So as soon as they come back for lunch, and I'm thinking in about an hour or so, they really took an early lunch today. And I guess because they wanted to hammer out the jury instructions. And when we come back, the defense is most likely going to rest, because I don't think they're presenting any witnesses. And we have already heard that Christopher is not going to testify. So we'll probably go directly into closing arguments and be handing this case over to the jury. I want to thank you so much for tuning in for our morning session. And we will start back up in the afternoon when they come back. If anybody was watching the Ronnie Walker trial, we are also streaming that on another live stream. So you're more than welcome to go check out the death penalty case. Ronnie Walker was convicted of the murder premeditated of Nylexia Alexander. Right now, the jurors are about to be presented evidence whether he should live or die. So that's another stream that's going if you want to tune into their tune into that case while while they listen to the evidence in regards to if he should live or if he should die. I want to thank you for tuning in. Don't forget to like, subscribe, and share. And remember, you're at the right place if you want no fluff, no filter, and just facts. So you can be the judge. All right, guys. I'll see you this afternoon. I'll start it up. I'll send out a reminder. See you soon.